was going to say, it's been there for years. What'd you do special? Went over and turned some justice. Then we went to Applebee's.
She told me I could cook, and that's okay, no problem.
Yeah, I don't cook much at all. I mean, you're.
Since it's 6 o'clock, I'll call the Charter Township of Comstock Planning Commission meeting to order. And if you would join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Our first item is the approval of the agenda.
I'd like to add something to the agenda, Chair. I'd like to add soil-friend stipulations and special exemptions, and if we could put it after the 766 Arden rezone.
Okay, and there's are we adding this to the agenda?
No, it's just the applicant cannot be here, so she submitted a narrative in her place for the rezone.
Okay. Well, if that's it, I would entertain a motion to approve the agenda.
I'll make a motion to approve the agenda for September 11th, 2025,
As amended.
as amended.
Support.
All in favor?
Aye.
Opposed? Motion carries. The next item is the approval of the minutes from August 28th. Do we have any changes or? If not, I would entertain a motion.
I make a motion to approve the minutes from the, August 28th, 2025 meeting.
Or, all in favor?
Aye.
Opposed? Motion carries. The next item on our agenda is citizen comments. A citizen may state their name and address and may speak only one time for no more than 3 minutes. This time may not be given to another citizen to expand or to extend their time. The person speaking has the floor and no other citizen shall speak during someone else's time. During this time, you will be making statements to the board without discussion from the board members. But you are welcome to make appointments, make an appointment with planning and zoning staff to discuss your comments further. Please keep comments clean and respectful. Okay, doesn't look like we have any comments at this time. I'll close citizen comment. And we'll move on to new business. And our first item on new business is 7667 Arden rezoning request and public hearing.
Thank you, Mr. Chair. We have received a rezoning application from Landscape Swarms. They came earlier this year, and they are just tacking this on to their previous rezone. And so this is at 7667 Arden Avenue. They're requesting to take it from R1B, single family, to LM, light manufacturing. bit of history on this parcel. It is 0.33 acres. It is currently undeveloped. In the past, there was a small home on it that was demolished when the company acquired it in 2024. Their hope with this parcel is not to have any sort of light manufacturing action on it. It would just eventually become a green space buffer to access the new drive that we're putting in. And this new drive will be, as you can see here, it'll occur right next to this Arden property. And their hope is to provide a buffer for those 3 houses on Lawndale for traffic, sounds, lights, that sort of thing. Kyle has prepared a staff report, so I will go over the 4 talking points of it. So the first talking point is whether the rezoning is consistent with the policies and uses proposed for that area in the township's master land use plan. It was deduced that the proposed rezoning appears to be compatible with the township's master plan. In the staff report, you can read more as to how he came to this conclusion. It is sort of a mix between general industrial and compact residential. Touch more on that in a second. The second topic is whether all the uses allowed under the proposed rezoning would be compatible with other zones and uses in the surrounding area. The development of the subject site would be severely limited if rezoned to LM light manufacturing due to the required dimensional setbacks. This lot is only 0.33 acres. That was exactly 14,000 square feet. So even though it will be rezoned to light manufacturing, or could be rezoned to light manufacturing, there's not many uses that could go on a parcel this small for light manufacturing. Kyle noted that because of the setbacks of 25 front yard, 20 side yard, and rear yard of 20, the lot pretty much becomes unusable. The third item is whether any public services and facilities would be significantly adversely impacted by development or use allowed under the requested rezoning. And it is not anticipated that public services and facilities will be adversely impacted. And due to these standards, the ability to develop on this particular site is severely hindered. Again, currently as proposed, they're just saying it would be a green space buffer with lots of trees and vegetation to, again, block that traffic noise and sound and lights. So no, we do not see that this would affect any services. The fourth item is whether the uses allowed under the proposed rezoning would be equally or better suited to the area than uses allowed under the current zoning of the land. It was deduced that the permitted and special land uses under the R1B district would be challenged to meet the dimensional standards of the district in terms of site development. Even if it stayed R1B and it could be a buildable lot, they would still be tough for space to create a home given our standards or any other uses allowed in R1B. So I'll go over the recommendations. There are 6 of them in findings. 1, it may be appropriate for the Planning Commission to determine if the intent of the area for the subject site is general industrial or compact residential. However, the area adjacent to the subject site is planned for industrial land development. 2, the applicant seeks the rezoning in order to have all subject parcels under the same zoning classification as the main portion of the site is LM light manufacturing. Go further on that. Landscape forms, the whole compound and complex is zoned LM, so they just want this to also be LM as it is going to be owned by them, or is owned by them. 3, the proposed rezoning is for an approximate 0.33 acres of land. The subject site has severe constraints in terms of developmental potential given a limited parcel width of approximately 50 feet. 5, the applicant intends to combine the subject site with that of 431 Lawndale upon execution of the rezoning in order to bring the parcels under one parcel identification number. 6, any expanded use of the industrial facility would be subject to screening requirements as listed within the township zoning ordinance, which will provide a buffer between the industrial use and residential use in the vicinity. As referenced in earlier review criteria, a site plan was approved by the Planning Commission in the spring of 2025, which reviewed landscaping and screening as part of the facility expansion. The applicant was unable to be here tonight. We requested to push it back one more meeting. They were not able to make that meeting either. So in her place, Jody Havera has submitted a narrative here. I don't know if Mr. Chair wants to read it. Pretty much just stating her plan or their plans with this parcel. Again, just hammering down that it would just be for green space due to the traffic that might bother the residential areas. A bit of history on the landscape form expansion they're working on, 300,000 square foot building that was approved. Will bring about 125 jobs in Comstock Township as a result of this project. That was a good just synopsis, and I don't know if you want to read this, Mr. Chair, if that you feel that was a good gist.
I don't think we need to.
Okay.
I think everybody read it when they got here.
Perfect.
I would open it for discussion with the board right now, since we don't have the applicant here.
Correct. We also have a public hearing tonight on this item as well.
Oh, yeah, but we'll do that after we we should do that first. So, I guess I would entertain a motion to open public hearing.
I'll make a motion to open public hearing.
Support.
All in favor? Aye. Opposed? Okay, we're in public hearing.
Nobody again.
Make a motion to close public hearing.
Support.
All in favor?
Aye.
Opposed? We're now out of public hearing. So I guess I would start with you, Bob.
Well, I have no problem with this. I mean, this is such a little piece of property, nothing could ever be done with it. The new parking road curves around. All this does is kind of box around it, so there's nothing there but green space. I mean, there isn't enough room to put a shed there, so I would be okay with this.
Amber?
Yeah, I agree. I would be aligned. I think it's actually going to be a bigger benefit to the residential space, to the side of it by what they intend to use the land for. So I think it's smart.
Joseph?
Yeah, I certainly don't have a problem with the rezoning. The only thing that I think maybe should be included in the rezoning proposal is the combining of the parcels. I think that's essential that take place to make the rezoning appropriate. And once that is done, I think the township could look at the possible vacation of that piece of Arden, because that property was the last one to need that stub of undeveloped road for access. And once the parcels are combined, it wouldn't need to be. So the township might want to look at that. But otherwise, no, there's no problem. It's appropriate and should be combined in with the other manufacturing parcel.
James?
I have no issue with this at all. I'm in favor of it.
Sandy?
I just wanted to ask Casey with what Joseph just said. Is that where the exit is when the employees leave work?
For the drive you're talking about, they are not coming out of Arden at all.
Okay.
That would
it's
just be.
Lawndale they're coming out of. Okay.
And in the final stage, they'll be coming out of M96. They'll be coming out.
Okay.
The main driveway will be out of M96.
As many employees as you have, you're going to need a stoplight there eventually.
Are you the VP of manufacturing?
I am.
Would you like to speak? I didn't know you were coming in tonight. Okay.
So no, I have no problem with it.
So this is a rezoning request. We can't put conditions on it, but you can recommend that it be combined into one parcel. If the letter, I see here the letter signed by Ms. Havera, the last sentence in the second paragraph says, it allows us to request consolidation of this parcel into a larger parcel in the future if we choose to do so. So, I mean, I think it's, obviously it looks like it would be used for a good purpose, but otherwise, as was mentioned in the staff report, if there was ever some desire to move light manufacturing activity in that direction, they still have to meet your zoning setbacks for buffering, landscaping, all that. But you cannot mandate that they join it together, but you can recommend.
I don't think all their parcels are joined together anyway. If you look at their tax bills, they've got multiple parcels there.
Yes, it makes sense, totally.
Okay, thank you, Attorney Kaufman.
But apparently they're not ready to do that yet from the letter. Okay. I guess,
Remember, if you want to make a decision tonight, you first have to decide to waive your bylaws, right?
right, we do. So do we want to move forward with this, or do we need to think about it?
I think we need to move forward with it.
Then And I would look for a motion to do so.
I'll make a motion, we waive our bylaws.
Support.
Let's do a roll call.
Okay. Do we need Attorney Kaufman to?
Oh, am I going to call the people's names?
No.
Oh, what the motion is. Okay, the motion is, if you vote yes, you're going to agree to waive the bylaws and proceed with the recommendation tonight. If you vote no, you would vote not to waive the bylaws.
And the vote must be unanimous.
Yes.
Okay. Commissioner Sherwood?
Yes.
Commissioner Lawrence?
Yes.
Commissioner Weintraub?
Yes.
Chair Nichols?
Yes.
Commissioner Kreitzer?
Yes.
Treasurer Bloomfield?
Yes.
Motion passes 6 yeas, 0 nays.
Okay.
I move that we make a recommendation to the Township Board to support the rezoning request of, give me a moment, 7667 Arden.
Support.
We need another roll call,
Okay.
please.
Yes. And then, Catherine. Okay.
Oh, let me say again. All right, sorry, I'm forgetting my duties. If you vote yes, you're voting to recommend approval to the Township Board on this rezoning. If you vote no, you are voting against recommending approval.
Commissioner Sherwood?
Yes.
Commissioner Lawrence?
Yes.
Commissioner Weintraub?
Yes.
Chair Nichols?
Yes.
Commissioner Kreitzer?
Yes.
Treasurer Bloomfield?
Yes.
Motion passes 6 yeas, 0 nays.
And you know what, when will this go to the
This will,
Township Board?
first reading will be September 29th.
Okay. Let's move on. And Soil Friends is the item next on our agenda. And I believe Mrs. Martin is here. Would you like to come speak to us?
Sure. You want me to get it started, or is it working?
Push the button on it.
No.
It's on.
Okay.
Maybe I need to go closer.
I do have a question for Attorney Kaufman quickly, though. I did receive an email discussing the stipulations many months ago, and I thought we would need a public hearing to bring them to the Planning Commission.
Before we take, so again, Soil Friends has a special use approval already.
Yep.
They asked that we reconsider their conditions based on recent court cases in the Peninsula Township case. If we are to change those conditions, we will have to have a public hearing. If you want to just allow her to present what she's asking for or what they're thinking about and talk about it, but we can't take any action tonight, if that makes sense.
Yes.
We could decide to schedule it for the next meeting or something like that, but we can't make a decision to change the conditions right now. Does that make sense?
Yes.
I think we need to hear what is being brought up, though.
Okay.
I guess that is the issue, is that we are not understanding why we need to come back for special exemption or special use and pay the fees again when some of these stipulations are conflicting with state law. So can I read the email that I sent that I thought that maybe Casey would send it to the board, to the Planning Commission, forward it to them. But I don't think that you guys got it. Read it. Right? Okay. Sorry. So this was back in July 13th, after the wineries up north won their court case. And it says, I'm writing in regard to a special exemption stipulation placed on Soil Friends LLC. After reviewing them closely, there are several items that appear to go beyond what's legally within the township authority. One requires additional approval if we ever decide to produce any alcohol beverage other than cider, such as beer or spirits. Another limit of the use is amplified music, even though the state permits it at licensed facilities. The third concern is a condition that restricts access through an easement that serves the property. Regulation of alcohol production and product type falls under the authority of the Michigan Liquor Control Commission. The state the state constitution and MCL 436-1201 established in the MLCC has complete control over alcohol regulation in Michigan. Local units of government are not granted the authority to regulate production changes once a license is issued. The MCL 436-1916 also permits amplified music at licensed facilities. While reasonable volume limits may apply, complete bans or pre-approved requirements are not supported under state law. The federal court ruling involving Old Mission Peninsula wineries made that clear. As for the easement, limiting access raises serious concerns about the fairness and legality of such condition. It's our understanding that zoning stipulations cannot be used to restrict access to the property with a long-standing easement. These stipulations were imposed during a period of significant strain and duress on our business. Cases like Country Mill Farms have shown how improper restrictions during these times can lead to serious legal issues for municipalities. While litigating is ongoing, this letter is submitted respectfully and with the hope that these concerns can be addressed directly. We're requesting a review of special exemption stipulations to ensure non-conflict with the state or federal law. Soil Friends is committed to operating responsibly in Comstock Township, and we expect lawful treatment and a fair opportunity to continue doing so. So after I sent that email, I got a response that we needed to resubmit for our special use, which includes a payment. And with these conflicting with the state law, we were just confused on why we needed to come again and start the process all over.
Okay. I appreciate what you said. I'm familiar with the case, and I saw, even more recently was this summer where the same federal district court here in Kalamazoo ruled about the damages and the rest of it. I just presented on this case to another township up in Traverse City, not the one that lost the case, but another township on this case just a week ago, so I'm very familiar with the case. It does mention amplified music, as you said. I don't know about your easement issue, and I'm not exactly sure about the change in your product. But the reason I recommended to staff that we require another special use hearing is because under law, the only way, under the Zoning Enabling Act, the only way to change the conditions on a special use is by mutual agreement of both parties. So I thought it was appropriate that we bring that back into this planning commission. You guys present, or you on behalf of Soil Friends present what it is you want to do, or, when we would have, and you are correct. The case did say you can have reasonable conditions on the amplified music, but you cannot totally prohibit amplified music.
Right, and that's what happened to us.
Right.
I was asked specifically if we could play the radio for Christmas music while people were shopping, and we got told no music at all.
It was amplified music outside, I thought, but I may not be right. I was part of the planning commission then, and some of the others here were as well. Outside.
We did allow for,
yeah, go ahead.
We allowed for people like a piano or a guitar.
So anyways,
like
yes, that was before the case came out. So yes, we understand it's different now. So whether we make them pay to come back for another special use approval, or to modify the terms of their special use approval, I do think we need to look at the terms of their special use approval, because there are some things from that case that conflict with what the original approval by this planning commission was. So I don't, it was my suggestion that they come back through the process. I guess that does mean I thought we would have you pay for it, but it's up to the township to decide if you want them to pay again or not. Now, again, and we'll address some of this a little later on. If you are a named party in this litigation, some of us here are a named party, we should not be commenting, okay? So just so we know that. I am no longer a named party. I was originally named. I was dismissed out in April or something like that. So I can talk today. So I do think it needs to come back to this planning commission. I make no opinion on whether they need to pay or not pay, but There are some things that since we first approved this special use that have been clarified by the Federal District Court. It went up to the Sixth Circuit Court of Appeals, it came back down. Actually, it's at the Sixth Circuit Court, their case, the pending litigation's at the Sixth Circuit Court of Appeals. But the wineries case was through Judge Maloney in the Western District of Michigan here in Kalamazoo, and it's very instructive as to the scope of what the MLCC can control, the scope of what local zoning can control, and where there's problems if local zoning is an overreach, essentially. So I do think we should look at it again. I don't care how we handle the process. I would rather have us mutually work on that and get this cleaned up so there's, I know there's pending litigation, but put that aside for a moment and just understand that if we have something sitting out there that probably doesn't comply with law at this point in time, we probably need to look at it.
I have a question, Attorney Kaufman. Would we require another public hearing?
My thought process is, without knowing more at this moment, if we are going to, so we would be allowing amplified music where we didn't allow it before.
I only asked that because I know that when they first requested special land use, there were some neighbors that submitted letters and showed up discussing the noise with their residences nearby.
But if it's a state law that's allowing it, it doesn't really matter what people have to say.
But should we not? I was inquiring about a public hearing.
Talk to your representative, right?
But in order to amend that special use, and, I would have to probably say we are going to hold a public hearing because that's part of amending a special use, okay? But you're right in the sense that I would recommend that we comply with law.
Well,
I guess
and to answer your question, you can put restrictions on volume and noise.
Sure, we have.
And yeah,
we can
we're
talk
fine
about
with that, but decibel, some type of measurements so that we are allowed to play it, right?
So
We're good with that.
So my question for you, Attorney Kaufman, is I guess where my head goes, and translate this to the world that I work in from like an HR standpoint and thinking about liabilities and risk there. So maybe a different situation, but do we complicate things worse by making it a burden to the business by asking them to pay when we potentially are just trying to come to the table mutually and say, let's solve this?
Let's fix it.
And I say that knowing that there is litigation and reading some of the documents here, like I think everyone would rather this get solved
Well, yeah, so
nicely.
I think that's a fair point. I think we have to leave the litigation aside because that's got its own pathway and its own, but yes, separate from the litigation, I would prefer we get ourselves in compliance with state law than not, if that makes sense, okay? And I mean, not just state law, but federal law, what the federal district judge has ruled. So, in essence, I don't know who gets to make that decision here internally, but I would rather get this thing going and schedule it for another, I don't know, Mrs. Martin, would you guys be able to put in writing what it is you want to do? Or so that we could, when we have a public hearing notice, we would be able to say what that would be? Or is that something you're not really prepared to do at this moment, or?
Well, I think that, I guess the specifics, do you mean like how loud of the music?
No, I just mean, our conditions before and whatever it was, 2023, or this, we would like you to look at changing or getting rid of or eliminating the conditions.
Yeah, that's kind of what the
Okay.
email covered, I think.
Okay.
Well, we also have stipulations on our hours too, which I don't think is
Okay.
covered by the state law.
Would you be able, if they decide, if the planning commission asks the board to agree to waive the fee, would you be able to fill out the application form so we could process it that way? Would that be too much to ask without having to, would anything change on your site plan? Would there be any addition on your site plan?
No.
Okay.
No. Yeah, it's just the
Just the easement, right?
Well, it's the easement, the hours, the amplified music, whether we're allowed to add on to our wine license, or
Okay.
we have to come to the board for all of those.
Okay.
Is what.
So hours, product, and music.
And easement.
And the easement.
There was one other thing that we did, which required them to come back every year.
If they increase their volume or change
Do-
alcohol use.
Do we need to do that?
Amber, everybody on the board should have gotten, when you sat down, it'll be a darker right here, Jim.
Oh, okay.
Which is the list that Ms. Martin did email to me.
Workout paused.
To the township treasurer. And I guess my question, and it sounds like you're all thinking that way, is we are in violation of how many of these I don't know. I think that's Catherine's answer to make, not mine or anybody else's.
Sandy,
Yes.
Mrs. Bloomfield, I'm sorry, but do you have the, I sent over the wineries, it's the,
Yeah.
from our attorney.
She does have that, yeah.
Okay,
All the
so
board
it-
members have that,
Oh,
except
okay.
Mr. Sherwood.
Yeah, so I was just gonna say that on there, it says the hours of operation, it has the law that covers that
You can't
it can't be covered by that. And then the music, it's on the page 4.
If I can interject quickly, I have a question for Ms. Kaufman, Attorney Kaufman.
Yeah, and so we have this, and then
Yeah,
this is the 2024 case. There's been a more recent one like this summer.
Okay, this is what Mr. Infante said to
Okay.
me, so.
Okay, I got it. So we understand, I guess, what would be helpful, because under Michigan Zoning Enabling Act, we can only change the terms, and to your point, Amber, obviously we want to change the terms if they're not in compliance with law. So I'm trying to find a way that we could do that lawfully with the Michigan Zoning Enabling Act, as well as to get this cleaned up.
So my biggest issue is that we are only, we have limited time that we're open. We're really busy right now. This is our time to capitalize to, do the best that we can do. So waiting another month to come in front of the planning commission, we're closed basically after that. Not closed, but we don't have as much going on as we do.
So are you saying you would like to wait another, what are you?
No,
don't
that's what I
understand.
mean, is that if we wait another month, it'd be
They're a
helpful.
seasonal business,
Yes.
is what you're trying to say.
So we need to move, so time is of the essence.
But
Yes,
we have to have
very
a public
much so.
hearing.
And that requires 25 days notice.
So that's my concern.
And I do
We
have a
to have
question.
public hearing.
Who has the power to waive fees? Would that be Township Board?
Yeah, I think they're the only ones that can.
I don't think we get to decide that.
Okay.
Yeah.
So it'd have to be presented to them. I don't know if we can do that by Monday. I don't.
So first of all, we have to find a way to do this as soon as possible for them.
If we could.
So we would have to notice it in the paper. I would, that's why I'm asking, would you, and obviously you're busy this time of year, et cetera, would somebody be willing to just fill out the application form so we have something to go from, attach your email that you sent back in July or whatever as the basis of what you want to address, and let's get a public hearing scheduled, okay? Then we can, whether we, as soon as possible, I don't know if people are willing to do a special meeting, I don't know, and get it done as soon as possible. Now, the only other thing we could do, which I'm hesitant to do, because we're in pending litigation, and I don't want to in any way indicate or mess that up, whatever position the township's legal counsel who's running that is sometimes we will sign an agreement to, I forget what we call it, but postpone zoning enforcement for a period of time to allow somebody to do something for a period of time.
Do we need to recommend that to the township?
Yeah, because I don't have the authority to do that on my own.
That's exactly what I was going to propose.
Yeah, we have some, I forget what it's called, but we agree that we're
enforcement.
mutually going to not enforce for a period of time, and we sign we do it like an agreement, okay?
Well, we're getting things in order.
I was going to say, is that similar to we say, okay, hey, this allows you to conduct your business while we do the due process of all of the
Yeah, it would
things that
say,
have to
we are
happen
going
to
to
make
allow
it.
you to have amplified music, we are going to allow you to, whatever about the products, we are going to allow you to use the easement for a period of 120 days or something like
Well,
that.
I have a
Until-
problem with the easement because it doesn't meet qualifications for
Is it out onto East Main? Is that
East
what it was?
Main,
It's just-
I don't have a problem with them eventually using it, but
Yeah,
before they get it ready, I think it shouldn't be used.
Right, we were told that we weren't allowed to use it whatsoever,
Yeah.
whether we do something to it or not.
So would
So-
you be able to wait on using that for a period of months, or do you
So
want
I guess that I'm just confused, because if we all know that these,
Because I
laws are-
can't, because we cannot change the conditions of the special use approval without going through a public hearing. So what I was originally talking about, are we going to increase what you can do or decrease what you can do? If we decrease it, I don't think we need another public hearing, right? We're going less than what was approved originally, 2 years ago.
No,
If
we're-
we increase, which is what the request is, amplified music and doing some other things, then I think we need to do, and I understand what you're saying, this is illegal, or it's not really, we could talk about nuances of what the judge actually wrote. But, you know, we can put reasonable conditions on the amplified music. We can put so I don't want to split those hairs tonight, but I do want to say, I think there's a way we could say we're going to withhold enforcement till we go through the special use process again, understanding the legal framework we now have to work within. And that obviously, my recommendation would be they're going to get most of these things they're asking for, if not all, okay?
Right, that's,
But I think time is of the essence, apparently.
right. And
Okay.
that's the justification. I mean, it seems to me that if she wanted to go to court, she could get an injunction against our enforcement anyway, because there's a conflict here.
Well, we're not going to enforce, so how do we?
Right.
How do we clean this all up so it's in compliance with state law and it goes through the process? Because let's put it this way, if I do this and just let you have it, somebody who doesn't like that decision, somebody who's aggrieved could challenge my process and, appeal that, okay? So I'm
There's
just
risk on both sides, so trying to find the middle road to say, how do we let you conduct the business you need to conduct while the township cleans up what we have to clean up so that we're all in compliance with the laws. So it sounds like that's a decent
Well,
middle ground.
Working together.
I
Right.
believe we need to do our due diligence, but I think we could put a referendum on enforcement until we do our due diligence.
Catherine, is that something that we can make a decision on the enforcement side?
No, the
We have to make a,
Township Board essentially
Yeah.
decides, so I think this.
I guess we need motions for all that then, don't we?
Well, what I think might happen, what might be a good idea, and of course you can tell me I'm wrong, is that the Planning Commission, makes a motion to request that our office prepare an agreement to, I forget what the word is, but essentially postpone or not undertake enforcement for a period of days, whether it's 90, whether it's 120 days, whatever it is, to allow, and then we're going to specifically going to talk about for amplified music, for the other things that are mentioned in her original email, easement, product, music, easement, product,
the hours.
and the hours.
amplified.
Okay.
Casey, how long do you think it will take us to do our due diligence to get it settled,
As far as public hearing or,
getting the whole thing done?
Well,
I don't know which.
when's that?
A guess, I know.
What's the next public meeting that we could get this on, Planning Commission?
October 9th.
October 9th, okay?
Okay,
So that's about a month, right?
yeah.
But I am curious as to fees. So if they did submit typical, and this is not a typical moment, we do not publish anything because publications could cost up to $250 until payment is sent. So do you want me to still send it off or wait? Because even the Township Board doesn't waive it. I don't know the procedure.
So I
for
think
this.
what we would have to do, this Planning Commission can make a motion, if you think it's appropriate, to allow the attorney to prepare an agreement regarding suspension of enforcement for a period of days. Phil, you tell me the number of days. And during that period, that the applicant must submit an application for special use approval, amending the special use, okay?
I'm thinking 45 to 60 days.
Well, we can talk about that in a
No.
minute, but it's not.
No?
And then,
No, they have to have a public hearing, it's got to go to the township.
right. And then also include that
That's-
we recommend to the township board
December or something.
that they waive the fees, if that's what you want to do.
I'm sorry,
Waive fees,
Yes.
waive the
I
application.
think we should.
I would like to see, you know, the attorney's report from our perspective and make sure that the changes they're requesting are all due to conflicts with state law. And if they are, there's no justification for us charging a fee. And so,
Right.
I mean, it would be,
Right. I know for the amplified music, it absolutely is, okay? We can put reasonable, because I just did this for another township.
The hours are too.
And the hours, okay, so I know those for sure. I'm not sure about the other products, but I have no reason to distrust what's being told to me. And the easement, that's the only one I don't really you know, obviously, we're gonna have to look at what that would be used for, and I need to read the case law again on that, because I don't remember that in the case law.
I understand.
I'm
and-
not
and
disagreeing.
That's why I think the very first step for us is to find out what your reaction to that
Well,
request is.
I
But
can come back with that in
not
2
to
weeks.
delay the process.
Right.
I think there's reasonable justification here to try to stop enforcement and let them do what they propose to do.
If we don't, I'm with you, if we don't request to waive those, I guess my concern is if we don't make a motion or to recommend waiving of fees, right, today, because we're waiting for Attorney Kaufman to come back to us,
I still,
that slows down their application, which then slows down. So if that's the case, fine, but we just have to make sure we build that time in then to our recommendation of time to not enforce. Right. So we just need to leave enough buffer if that's the route we want to go, that we're not hindering business operations while we're waiting to decide should there or shouldn't there be a fee.
well, we do know there's at least 2 things.
Right.
That
Yes.
conflict.
So we need to address those to get ourselves
Right.
in compliance
Right.
anyway.
Correct.
And those alone would justify the cost of the public hearing and stuff.
Right.
Even if there were no
Correct. Right.
other
Right.
requests to consider.
Right, so the fact that we have to have a public hearing is not their fault.
No.
Right.
Right.
So, as I'm saying,
I
so, you
I
know,
would think if we can achieve this moratorium on enforcement, it should be for 120 days.
So is it, should I make a shot at a motion? Is that
Sure.
doable?
Go ahead.
Okay, so I move that we request Attorney Kaufman to write a document, I don't know what you want to call that document.
Legal opinion,
A legal opinion, regarding suspension of enforcement of the zoning regulations,
Enforcement?
A special exception.
the special exemption
special-
at Soil Friends business site, and a recommendation that we waive the fees involved in revisiting that special exemption.
Good job.
so that's the motion that,
Support.
okay.
I was waiting.
Are we, is it just one motion,
Okay.
separate motion?
Is that all one motion? I think so, yes? Okay.
So when it-
And so was to have Attorney Kaufman
Write a legal opinion regarding suspension of enforcement of the special use permit at Soil Friends business site,
and to waive
and
fees.
to recommend, and to recommend waiving fees that would be involved in revisiting the special use permit
For how many days?
So does that have to be approved by the board?
for 120 days.
Okay.
Sorry, Amber.
I believe it does have to be.
That would
approved by
have
the
to be
board.
approved by the board, so there's a meeting Monday night,
Yeah.
if it's at all possible to get that on the meeting Monday night.
Okay.
And then if that's the case, not, what I'm wondering is I need to come back to you in a couple weeks with my conclusions, and then we're gonna decide, or we're asking the board to allow us to just suspend enforcement against them for a period of 120 days, right?
Yes.
Okay.
That should give us enough time to then
Figure it,
the
yeah.
process side of it.
We have a motion with a support, and Casey, would you do a roll call?
1 second
I
here.
have to ask the board if I can recuse myself.
Yes,
You're
you
gonna
need to.
abstain on this, thank you.
One moment. Commissioner Lawrence?
Are we going to explain what the,
Oh,
Gosh, I might, okay, yes, we are, Jim. All right, okay, so the vote, if you vote yes on this, you are going to vote to support me preparing a written legal opinion regarding suspension of the Peninsula Wineries case, analyzing it, and deciding should we recommend suspension of zoning enforcement of the special use conditions on Soil Friends for a period of 120 days, and to recommend to the Township Board that they waive the fees for a new special use application to amend the conditions at Soil Friends. Does that sound right?
Yes.
Yes.
Okay. If you vote no, then you're against all that. And we have one abstention.
perfect. Commissioner Lawrence?
Yes.
Commissioner Weintraub?
Yes.
Chair Nichols?
Yes.
Commissioner Kreitzer?
yes,
Treasurer Bloomfield?
Yes.
Motion passes 5 yeas, 0 nays, 1 abstain.
I do have a question for the attorney. So it will be possible for us to add this to the agenda for Monday night? And do you all think that that's something that, as your liaison for this board, that I should do to move this forward?
I would think so. I mean, we just voted 5-0 that we need to take some action here so that we can get the township in compliance. I don't think we can risk a $50 million lawsuit.
I agree, that's why I brought the question up.
So from me, Attorney Catherine Kaufman, am I preparing the public hearing or not right now? I don't know if fees are getting waived.
I don't know, well, first of all, we're going to prepare the public hearing. We're going to figure out if we waive fees or not, okay? Because we want to move this as soon as possible, but we're going to need Mrs. Martin or someone on her behalf to fill out an application, okay? Somebody's got to get to the clerk or whoever puts things on the agenda for the Township Board to see if this can be added for Monday.
It can be added right at the meeting.
Okay. So that way we can, get some movement and maybe input from them as to whether, and I will explain the same analysis on Monday night, like we need to get in compliance with the most recent court case.
Okay.
Thank you guys for your time.
Thank you.
Just for, real quick, just for clarity for Mrs. Martin, would not recommend taking, we're still enforcing until this goes through the board. So just
Yes.
wanted, I would hate for somebody to
I really
think that
I
this was
don't,
the
but
decision.
I do not want really anyone to go out and enforce something that has been determined to be unlawful in a district court case.
And one more time for clarification's sake. So
Wouldn't be good.
if I come in Monday, I receive the application, I am then kicking it to the Gazette even though no fees have been paid or waived?
Even though no fees have been paid.
Or waived? Okay.
That's what I'm saying, and if I need to talk to Scott, I'll talk to Scott.
Okay. And I would need an application by next Wednesday to meet that requirement for the Gazette on the 9th.
Okay, by next Wednesday, we got to have something in writing, the application form. You're just going to write on there, no changes to the site plan, okay? And then you're going to list out whether you attach your email or whatever.
Okay.
That says these are the things we're specifically asking you to look at again.
Okay.
Okay?
Yep. Sounds
All
good.
right.
Okay, thank you.
Okay, thank you.
Thank you. Okay. Old business. Do we have any old business?
Nope, you missed one.
Closed session.
Oh, yeah, we do have one closed session.
That's all right. I got baby Jesus.
See what I got?
We're going to move into closed session next,
Well,
right?
first of all, let me just say, I have a motion prepared to go into closed session to discuss a written legal opinion. I put all of these opinions in one opinion. I forgot that the treasurer doesn't want anything to do with her in a closed session, so that's my fault. We have to have 5 of the 7 members vote to go into closed session. So if I get any less than 5 vote to go into closed session, then we are not going to go into closed session, and I'm not going to talk about this written legal opinion tonight. I will pass it out to you at the end of the meeting. You can take it home, you can read it. If you wanted to waive attorney-client privilege, I would never recommend that you do this. Absolutely, it's against my recommendations. Sometimes stuff like that happens anyways. Then it could be discussed in open session, but I strongly recommend against that. So we have a motion, somebody can make that motion, somebody could second it. We have to have a roll call vote, and we'll see if there are 5.
I move that the Planning Commission Board meet in closed session under Section 8(1)H of the Open Meetings Act pursuant to Section 13(1)G of the Freedom of Information Act to consult with our attorney regarding a written legal opinion.
Support.
Do a roll call for
Okay,
all
let me
6
just
of them?
explain. If you vote, and we're going to do a roll call, if you vote yes, you're voting to go into closed session. If you vote no, you're voting to not go into closed session.
1 sec. Okay, Commissioner Sherwood,
Yes.
Commissioner Lawrence,
Yes.
Commissioner Weintraub,
Yes.
Chair Nichols,
Yes.
Commissioner Kreitzer,
No.
Treasurer Bloomfield,
No,
motion has failed.
we are not going into closed session. What I will do at the end of the meeting is I will pass out the written legal opinion. It is, of course, I'll remind everyone, you need to keep it confidential. It is attorney-client privilege. You cannot discuss it with anybody outside, yourself, and do not discuss it with anyone else. If you do, it's a violation of the Open Meetings Act. So please keep it confidential. If you have any questions for me, you can call me, you can email me, we will discuss it.
I don't know, that costs money.
I'm not here for the fun. Okay,
When do we get to discuss it? How does that happen?
If we have another meeting where we can get 5 votes to go into closed session, we can discuss it.
Otherwise, it just is what it is.
Otherwise, it just is what it is.
Gotcha, understood.
Catherine, there were multiple requests for reports. These are all in,
I put them all in one.
Okay.
Now, if in fact you want me to, you could, after you read this, okay, you could direct me to go back and separate them out into 4 different opinions. A lot of the analysis the legal analysis is the same underlying legal analysis that applies to each of the 4 separate specific fact patterns, if that makes sense. Okay? So, on
Okay.
the rest of the agenda.
I guess we're moving on. We'll go to old business this time. Do we have any old business?
We do not.
Any other business?
No, any other business? No, sir.
Okay. We're going to go into citizen comment, and as I stated before, those are what we expect. I'm not going to read it again. So if we have any citizen comments, now's your chance to speak. I guess I will close citizen comment. And at this point, I'll ask Sandy if there's updates from
Other boards.
the board.
Okay, just a couple of things. August 18th at the Township Board meeting, it was the second reading of Ordinance 554, which was the mobile food ordinance. That one passed. And the other ordinance on the agenda that night was 557, and that is the rezoning for 6668 East ML, and that one passed. Coming up on this coming Monday's agenda, Brett, myself, and Deputy Treasurer Knight have been working on a bills payable policy. So that'll be the 3rd time that this comes before the board. And it is time to work on budgets, and Superintendent Hess and Brett have been working on those, so it'll be interesting to see what happens with that. As we are hoping to maybe get some money for sirens if the board so chooses to do that. Also, Chief Financial Officer Brett Paget will be talking about millage rates and where we're at, so that's an interest to everybody, so probably be a good thing. And it's quite complicated, but Brett does a good job explaining it, so hopefully you chime in for that one. And that's all I have. Oh, no, wait a minute, I'm sorry, I have one more thing. I have the CABA reports. So for the month of July, I will start in July, Comstock Township, let's see, that's year to date, so I don't have that one, let's see. Looks like we had 692, does that sound right, Casey?
It does. Been very
She's
busy
been
in that
working.
office. Yes.
Okay.
Special meetings, permits.
That is for 1 month. For year to date, Casey, correct me if I'm wrong, 332,000.
Yes, so that also is including electrical permits
Yep.
and all that, but yeah.
Correct. And then for the month of August, that came in tonight with the board packet, August is a slow month.
Yes.
It looks like we dropped down to 77 permits is all, and only $18,000. So that's that. That's all I have.
The zoning board hasn't met since our last meeting, so I have nothing to report.
And won't meet this month either, for both.
Okay.
Canceled.
Training updates?
Yes, so I introduced last meeting that there is a MAP conference going on October 23rd to the 25th, I believe are the dates. Planning commissioners are invited to attend. You guys will be using the planning training budget. So there are about 4 more spaces left for if you guys want to attend. I passed out the agenda for both Wednesday and Thursday last meeting. So if you do want to attend, please let me know by like next Wednesday, or no, this Wednesday. So in like 6 days.
Okay, thank you. Information, future action items?
Yes, I wanted to confirm that everybody's aware that on September 25th from 3:30 to 5:30, there's a special meeting with Emily Petz from the Outdoor Institute. We talked about that about 2 weeks ago. Wanted to confirm that most of you guys can make it. Hopefully a quorum can attend. It'll be a workshop style before our regular scheduled planning commission meeting. She has action items for our housing study that she would like us to work through. And I think the ultimate goal is to have that full housing study completed by November 13th.
What is that date again, Casey?
September 25th, 3:30 to 5:30, before our regularly scheduled PC meeting.
And then we'll have a regular meeting at 6.
Yes.
Thank you.
And then I was rewatching the previous meeting last Thursday, and I don't believe we confirmed a time for our October 30th best public hearing. So I need to get the notice out, but I did not have a time to do that for. Were we doing 4 p.m.? It's a special meeting. 6 p.m. What are you guys thinking?
What was the date again? Can you remind me?
October 30th.
Thank you.
Okay.
I need a time for that. If anybody has any ideas.
I guess, what's everybody think about a time on the 30th? Halloween?
I thought we had talked about the 16th.
The 16th is the CIP workshop. The 30th will be the public hearing. So
What
that would
time, what time is the CIP workshop? That's
3:30 to 5:45. October 16th. October 16th, we have a CIP workshop special meeting from 3:30 to 5:45.
and then a meeting after that as well.
Meeting after that at 6 o'clock
Okay.
So we're removing the 23rd meeting up to the 26th.
for the map.
Correct?
Correct.
And then the 30th is what we have to figure out.
For time for
timing.
for the public hearing. Correct. We've been doing 4 for special meetings. I don't know what you're doing 4, if you want to change that.
I think 6 would be better for a special meeting for a couple of reasons. One, I think that it allows those of us that are working to get here, and I think more importantly, it allows citizens who are working to be able to get here if they want to be a part of those meetings.
Gotcha. Everybody in agreement?
I agree with what Amber said.
Can you make?
Yes, I do too.
I can, I'm gonna have Rob Fall come.
Okay.
And what time did she say, 6?
6 p.m., October 30th. That is the only item on our agenda, the best public hearing.
Okay, I'm gonna make Mr. Fall come. I'll be on vacation.
Okay.
Well deserved.
And then I have one last talking point, just outline of the meetings coming up. October 25th is a very light meeting. We had a rezone schedule. The applicant cannot make it, so they requested we push it back to October 9th. So we have no applications for the 25th. We can either cancel that since there are no applications, or we can meet to discuss accessory structures and the chicken ordinance.
I think
We should do those.
we should do that.
Yeah,
September
because if
25th.
we don't,
September 25th. Yes, sorry.
if we don't do that, everything will all of a sudden fall on us.
That's what
The
happened.
chickens will come home to roost.
That's right.
Okay. So that'll be the only, a lighter meeting.
Casey, is there a way you can send an email with these
Yeah,
dates
so-
and times so we can work on our calendars?
Yes, I kicked an email to you all, but things changed. Like the 25th was gonna be best in the rezone, but that's axed. So I don't know if sending emails to you all will be beneficial when things change.
You have to send them so we can at least get the original meetings on our schedule, right?
Right.
Yes.
Okay.
Yes, so we know, have an idea what we're doing.
Yeah. I can do that. I think that's all I have for you guys.
Okay. Planning Commissioner comments. Bob?
Oh, I was just gonna ask about the accessory building thing. It's getting late in the year, so a lot of people wanna build winter sheds.
The 25th.
Yeah, I got that now. I'll be in Munising. I won't be here.
Amber?
I don't think I have anything. Thanks for running through the meetings because I was panicked all day today that I was like, is it 4 or 6? I'm planning on 6, but I hope it's not 4. So thank you for running back through that. And yeah, that's all I got today.
Joseph?
I'm good.
James?
I'm good.
Sandy?
No comments. Thank you.
Good meeting, everyone. Meeting's adjourned.
And I'll give you your memos as you
Okay.